Okay. Hello, everyone. Lovely to see you on such a nice sunny evening. My name is Megan, and we're here tonight to look at how to complain effectively about the LA in relation specifically to Send. Just want to check that everybody can indeed see the PowerPoint. If you can't, can you please say now? Natalie says, if you can't, leave the meeting and rejoin with your camera on, and then you can turn it off again. Speak now. Just from my perspective, I have 3 kids who are running around and 3 dogs, one of whom is a puppy. So I will endeavour to not be disturbed, and my husband ought to turn up at some point in the near future. But if I start talking off camera, there's probably a child looking at me with concern, and I'm throwing the puppy treats to reward her for sitting nice and quietly. So that's what I'm doing as I kind of reach up to the side. So apologies. I have to have my conservatory door open as well, otherwise in this wonderful heat, I will slowly melt in front of you. So that does mean I'm slightly more likely to be disturbed, but at least you'll have more of a functioning brain from me. Okay, so we're going to look, as I say, about complaining effectively about the local authority, and this is specifically in relation to Send. And as we go through, I will make it more clear why we're being so specific there about this being to Send. I think before we think about this, it's important to understand the context of what we're complaining about when we're complaining to the local authority. And local authorities have the right to take action as a result of public law. And there are various different public law is a set of rules that govern the relationship between us, the private individuals, and various public bodies. And in this case, we're talking specifically about local authorities. And there's different laws, acts of legislation that provide the local authority with powers, and we call these statutory powers because they're underpinned by law. And this gives them the right, it gives them the duty in some cases to make decisions and to take action. And this can come various different types of legislation, so acts of parliament, and sometimes details are put together in regulations, and there might be kind of orders and rules. And the sorts of laws and regulations that we might refer to in this context would be things like the Children and Families Act 2014, the Education Act 1996. I might look at the Send regulations, the personal budget regulations. They're kind of the ones that we're probably going to look at and refer to the most often in the context of complaining about Send. Now, there are principles that the local authority must abide by when carrying out their duties. They must act lawfully. In other words, they must follow the law. They mustn't do things that they don't have the power to do. They mustn't be improper, and they must follow guidance and policy unless there's a good reason not to. And when you read guidance and policy, you'll see where it says local authorities must do something, which means that there is a piece of law that says that they must do that, or where they should do something, and that's something they should do unless they've got really good reason for not doing it. They must act rationally. In other words, they must be reasonable in the decisions that they make and the actions that they take. And they must act fairly. They mustn't abuse their power, and they must follow procedures to reach a decision. They must be unbiased, and they must treat people equally. And we'll see as we go through the procedures that they set up. And for example, their complaints procedures. Part of being fair is ensuring that they follow those processes and procedures that they set up. I think people often get confused as to the different routes that are available to them for making complaints particularly about a decision made by the local authority. And depending on the nature of the type of complaint you want to make and what other options are available to you will impact the route that you take. And so we've got this flowchart here, which gives you a way of working out what route you ought to take. So the first question you need to think about is, are you challenging the actual decision made or the process by which the decision was made? So if you're looking at challenging the decision, so that might be the decision not to undertake an EHCP needs assessment. It might be the decision to name a particular school in section I of an EHC plan, for example. then the question you need to ask yourself is, can I appeal this decision? So can I go to to send this to the tribunal and ask them to consider this decision again? If the answer is yes, it's an appealable decision, then your route to redress there, a route to challenging that decision, is to put an appeal to the first tier tribunal. So those are things like refusal to assess, refusal to issue, an appeal against the contents of sections B, F and I of an EHCP, for example. If you want to challenge a decision but it isn't appealable, that's when you would look at following the judicial review process, and we'll touch upon that towards the end of this this presentation, this webinar. So, for example, what you might want to challenge is the local authority's decision not to provide your child with education whilst they were unable to attend school, for example. And that's not an appealable decision. You can't get to first tier tribunal, but you could look at doing that via judicial review. You can look at that decision. You can challenge that via this other process, which is going through the complaints process. But you'll need to think about the outcome that you're attempting to gain there, and we'll talk about that as we go through. If you want to challenge how a decision was made, then that's when you would be looking at the complaints procedure, the local policy complaints procedure, following their various stages. And if you still find the resolution that they offer you unsatisfactory, then you would be looking at taking your complaint to the local government ombudsman, and that we refer to as the LGO. So they're your different routes, and they're all they've got different reasons for going down each avenue. So we're not looking at appealing a decision today. We're not looking at first tier tribunals because that has a whole process in and of itself, and it's got its own steps and its own timelines and dates and so forth, and that's covered in a number of different webinars that we offer. So we're looking in this instant at making complaints via the complaints process, and we're going to touch briefly upon judicial reviews. But if we're thinking firstly about making a complaint about how a decision was made, therefore using the local authorities' complaints procedures. Some basic tips is, first of all, complain as soon as possible, and certainly within a year of the situation occurring. Make sure your complaint is in writing, and make sure that they know it's a complaint. So be clear, perhaps in the subject of your email, if that's how you're doing it, or in the letter that you write, that you are making a formal complaint. Try not to include too much information. Be quite clear in what it is you've got to say, but also keep it relatively brief. Obviously, you need to provide some details, but make sure that the information you're providing is completely relevant to your complaint. And it's really important to be clear about what it is you're complaining about. So are you complaining about their failure to provide a service? Are you complaining about the fact that they haven't followed a particular law or particular guidance? Have they failed to follow a process that's set out in law guidance, or that they have set out for themselves? Are you complaining about the fact that they weren't fair in how they've done that, for example? Provide evidence. Again, you don't want to put too much in there, but if there's particular emails that prove your point, then you might want to refer to them. Explain the impact of their failings on you, on your child, on your family, and explain what you want to achieve by the complaint. What would you like the outcome to be? Okay, so the first thing that you need to know when you're going to make the complaint is, what is your local authority's complaint procedure? And each local authority has the right to create its own complaints procedure. And what they then need to do is to stick to their own procedure. Now, you'll find that for standard complaints, there are two stages to it. So the first is what they call a local resolution, and the second can be called either the investigation or the escalation stage. And different local authorities will have different timescales and so forth. So you need to go away and look at your local authorities' procedure that they set for themselves, but also be aware that they can change. So certainly Surrey County Council has changed its complaints policy at least in the last year, certainly since I wrote that last PowerPoint. Now, just to give you an example of how they can differ, I've looked at 2 different complaints policies for different local authorities. So, for example, with Surrey County Council, their stage 1, they give themselves 15 working days to respond, whereas in Kent, just over the border, they give themselves 20 working days to respond to a stage 1 complaint. Surrey at stage 2, they allow themselves the right to decide first whether to investigate or refer back to the department. And they don't give a timescale of how long that should take. But then they state that if they do decide to investigate, they will come back to you within 25 working days. Whereas Kent simply say that they'll respond within 20 working days, but 65 working days if they say that it's more complex. They don't say how they decide whether it's more complex. The point is that you, just because you know your local authority's complaints procedure, if you're talking to other people, it doesn't mean you know what theirs are. You can't assume that they're similar, as you can see from those examples. But also don't assume that it's still the same as the last time you made a complaint. Because like I say, Surrey have changed theirs relatively recently here. So you need to know what they're saying that they will follow, and then that's what you can hold them to. And part of what we were talking about earlier about they have a legal responsibility to be fair, part of being fair is following their own process. So they can set the process, but then they've got to follow it. And if they don't, then that can often become part of your complaint as you escalate it through the systems. What's important to know is that social care complaints are different. Social care complaints are covered by statutory guidance, and therefore the process and the timescales are homogenous across local authorities. And there's also 3 stages to the process. So there's a further stage 3, where they go to, I think, an independent investigator. So if you're making a complaint about social care, just be aware that it is different to standard processes. So if we had a look at the tips, we're going to have a look at this in slightly more detail about what you might want to include. So obviously you need to include some context into your complaint. Now, I think this is the part that can often be quite tempting to provide an awful lot of information, and also provides a lot of subjective information as well. And I find that one way of managing that in a way that makes it really easy for the person to read, but also easier for you to kind of put the facts together and stick to the facts, is to consider giving them the basic facts of the situation in chronology. So as I've given the example here, April 23, school applied for an EHCP. May 23, assessment started. June 23, attendance began to be affected by anxiety. In my head, this is a failure to provide Section 19 alternative provision, is what I'm sort of thinking here. But it enables you. I find that one of the most challenging aspects as a parent of writing these complaints is my own executive function, which is poor at the best of times, but also it's emotionally exhausting to kind of go back over all of this and trying to kind of put that all and work out how to put it into a sort of a paragraph where I can find quite challenging at times. So being able to lay it out in this way, I think is a way of starting your complaint in a helpful way. But I also think, as I say, it makes it much clearer for the other person to read. Once you've established the facts of the matter and the chronology of the matter, then it's going on to actually say, okay, what is it you're complaining about here? And I think one of the places that complaints can often not be effective is when the person making the complaint isn't clear about what it is they're complaining about. Who is it?
Daddy's calling you.
Oh, I'm really sorry. I'm going to have to get this. It's my husband. Hello? Second, because he should be home. I promise you I'll be very quick. I'm in a webinar. What do you want? No. Right. Bye. My husband checking about his stomach. Have I cooked for him? Which is very helpful. I thought he was phoning me because it was an emergency. Apologies. So be really clear about exactly what your complaint is. So is it that they failed to follow a piece of legislation? So for example, failed to provide an education under the 1996 Education Act, Section 19. Did they fail to follow processes that they have set up, that they need to keep you informed of certain information, for example? You know, Children and Families Act is quite clear about a number of timescales, for example, that they need to keep to. Have they failed to keep within statutory timescales? So what I think it's worth doing is separating your complaints out under numbered bullet points and saying what they are, and then explaining, if you need to in more detail, exactly where they went wrong. And for me, I think it can be helpful to think about the kind of what, where, when, and who. So when I'm looking back over it and thinking, have I addressed the issues? Have I been clear about these things? What happened? When did it happen? Normally it's going to be via email. You know, where were the failings? But again, keep it to the point. It's really tempting to kind of provide all of the extenuous situation, but actually that can often detract from the point that you're trying to get across. Think about that headline complaint that you're making. Is the information you're including really relevant and helping you make that point? Is it helping you evidence that point? Then within this, you want to think about what was the impact. And when we're thinking about impact, we might be thinking about the impact on you as a parent. It might be time, stress, money. You know, you may have paid for your child's alternative provision. It may have caused you a huge amount of anxiety. It may be an impact on your child. So it may be an injustice in the fact that they haven't been accessing education, for example, or they haven't getting the right support, and therefore that's led to the failure of school placement. And there may be a wider impact on the family. But I think often keeping it to kind of yourself and your child is quite helpful. And then don't be afraid of telling them what it is you want them to do to put this right. It might be that you're looking for them to issue an EHCP that they should have issued following an annual review. Although I'd probably do that via the judicial review process. You might want them to provide you with the panel meeting minutes that they haven't got. You might want your caseworker to contact you because they failed to contact you. You might want an apology, for example. So what is it you want from them? You might want compensation. You might want them to refund you for the money that you spent on providing an education for your child. I will often point them to local government ombudsman guidance on financial remedies. And if you Google it, you can find their guidance and say, I want you to follow the LGR's guidance on remedying this situation. So really don't be afraid of telling them exactly what you want them to do there. Here I'm sort of saying, you know, what might that be? The one I forgot about there was you might want them to agree to make changes. Sorry, children. It's gone quiet. Do you want them to provide more training for their staff? Do you want them to improve their policy? So, for example, you know, if your case officer has left yet again and no one has told you that they've left and you've struggled to find out who your new caseworker is, you know, do you want them to look at that policy for how to deal with caseworkers leaving again? Do you want an update on progress, for example? So that might be something you want to address. Sometimes you might just want acknowledgement that they've got it wrong, but those are the sorts of things that you might be looking for there. If you think that they have breached the law, then you can look to go to the monitoring officer, and you should be able to find out who your LA's monitoring officer is on online. They do have a personal responsibility for considering matters that are referred to them about breaching the law. Daddy, he'll be home very shortly. Okay, he's on his way. The monitoring officer, if they become aware of any proposal or decision or omission by the local authority that is going to lead or has led to them contravening the rule of law, then what they must do is prepare a report, and they then must provide that to the members of the local authority so that they can consider it. And this is a must. I must confess, though, it's not something I've ever had success in doing, is getting the monitoring officer to look at anything. So it's certainly worth a try, and it's certainly worth looking at what their roles are. But as I say, it's not something I've had success in. And certainly when I'm looking at complaining, it's because I want something to happen. I either want them to take action, I want to elicit some form of response, some form of contact, or I want them to look at compensation, for example. So I haven't found this useful, but nonetheless, it could be something worth considering. And you might have a more effective monitoring officer at your local authority as well. So if you've done your stage 1 complaint, which is looking for a local resolution, so that is when your the department that was dealing with the initial situation looks at it and tries to resolve it. You weren't happy with the response, so you've gone to stage 2. You've asked for the local authority to investigate that, to see if they find fault. You've had the response from the local authority and you're not happy with the response. The next step here is to contact the local government ombudsman. Now, their remit is as follows. They are basically set up to monitor the behaviour of public bodies, and it allows the public to challenge the administrative decisions of public bodies. Okay, so it's not looking about the merits of the decision. So it's not deciding whether the decision they made was right or wrong. And they can't interfere where the public body has discretion over particular issues. But it's looking at, did they follow their processes? Did they follow the law properly? Which is why, if we're looking at failure to undertake a needs assessment or failure to issue an AHCP, that's dealt with by a first tier tribunal. That's where you're challenging the decision. So the LGO is specifically about the process, the administration behind that. And the remedy that you're seeking has to match the issue being challenged, and they also have to have the remedy has to be effective. So this is the guidance that they have to follow, premise they have to follow. So if we're thinking first of all about, has what's happened caused injustice, we need to think about what the LGO defines as injustice. And they have two ways of looking at injustice. First of all, they think about objective injustice, so just injustice that you can prove. So, have you suffered a financial loss that you can prove? Has there been a service that you ought to have had that you haven't had? Has there been damage to a property or amenity? Have you had a loss of opportunity? So largely here, we're probably looking at financial loss and loss of opportunity is one of the areas that's going to cover our complaints that we're making. And then there's subjective injustice. So injustice that's hard, it's difficult to prove. It's based on your outlook on it. And here you're looking at distress or hurt feelings or outrage. And that's obviously quite a large area that comes under the sorts of complaints that we're making. And it's important to know that it is subjective. So they will make a final judgment on the level of the distress that they feel this incident has caused. And so I certainly know from personal experience that I don't always agree with what level of distress they think has been caused. And they have set remedies that they can that can happen as a result of your complaint to them. And the purpose of it is to restore, to put you back into the position that you would have been if the maladministration, and we'll look at that word maladministration in a minute, hadn't occurred, as far as is possible. So that's what they aim to do. And so they may therefore recommend the local authority apologises for what's gone wrong. They may recommend that they now put particular services in place that your child should have had before. So they may have, I don't know, cancelled a holiday club for SEND kids that you've said an injustice that they've done that, and they made it perhaps that they should provide that service. They may tell the local authority to make a decision it should have done before. They may tell it to reconsider a decision it didn't take properly in the first place. So remember, this isn't reconsider a decision because they think the decision was wrong, but that the process they'd followed to make the decision perhaps wasn't the right process. They may order them to improve their procedures, and they may order them to provide financial remedies, so for expenses incurred or for distress. So those are the sorts of things that we might look to get out of it personally. What are the conditions for complaining to the LGO? So they won't accept a complaint if they deem it to be inextricably linked to the issues that if you're appealing to a SENDIST. So, for example, if you're in appeal for sections B, F, and I of an EHCP, and you've complained to the LGO about failure to provide alternative provision, there are times when they might make the decision as inextricably linked to the decision before SENDIST, and therefore they won't investigate it. So, when you know you're in appeal or you have appeal rights and you want to complain to the LGO, you need to make sure that the complaint you make very clearly sets out that you're looking at the administration behind the complaint, and be very clear how it's not addressable by appealing. You still won't always necessarily get the outcome from the LGO that you want there, but make sure that you give yourself as good a chance as you can by being really clear about that. You also must have exhausted the council's complaints process first. So you must have gone through your stage 1 and stage 2 complaints. And if you haven't, then you simply point you back to the council. And your complaint must be made within 12 months of whatever it is that's happened. Now, in some cases, the situation you're complaining about may have gone on for some time. So, your child may have come out of school in September 23, and that hasn't been resolved until January, March 25. So you're looking at making it within 12 months, sort of March 25, so making the argument that it was an ongoing issue, and it only ended on a particular date. But nonetheless, always try and get your complaint in as soon as possible from a situation. So when you're thinking about what you're saying to the LGO, you don't need to submit an awful lot of information to them, particularly if your stage 1 and stage 2 complaints were quite clear. But what it is worth doing, if you need to add anything to the chronology, then you can add to that from what might have gone into your original complaint, and be clear about which local authority you're complaining about, which department you're complaining about, people if necessary. Where you think there's been, so remember what the remit of the LGO is, which is investigating maladministration, investigating and failure to follow administrative processes. So be really clear where you think there has been maladministration, and make sure you stick to the point. I think it's really easy to misunderstand what it is the LGO can investigate, and therefore include a lot of irrelevant information. And I think that then makes it harder for you to get the resolution that is possibly the right resolution. If you know which laws the local authority have failed to follow, or which regulations or guidance they've breached, tell them which ones you think it is. So, if they fail to provide alternative provision, then, tell them they failed to meet their duties under Section 19 of the 1996 Education Act. If they have refused, there's also the guidance for providing education for children who are too ill to attend school, and talks about, providing alternative provision within 15 days. So point the LGO towards the legislation and guidance that you think that they've breached. If it's about their own processes, and particularly if there's public record of those processes, then tell them what it is they've breached. So if their own website says that they'll respond to stage 1 complaints within 20 working days, then say they've breached that. Likewise with stage 2. Or if there's other processes that they have put on public record that they will follow, then it is fair, reasonable that they should follow those. So tell them where they failed to do that and point them to the public record. Talk to them about how it's caused injustice, like before, to you, your child, and potentially the wider impact. And I would keep that pretty brief, because a lot of what you want to say is already in your stage 1 and stage 2 complaints. So include those, include your local authority's responses to those. And you don't need to provide an awful lot of evidence, because the LGO will go to the local authority and ask for evidence. Occasionally, if there's a particular bit of evidence that you think is absolutely vital and might include that, on the whole, they'll get it all from the LA. So we've talked a lot about this word maladministration. What do we actually mean by this? What we're thinking about there is, what is it they have done wrong? So these are the sorts of things that come under maladministration. So where they have delayed doing things or haven't done things, and that might be delayed making a decision, delayed providing you with the outcome of panel meetings, for example. They might have done things wrong. They might not have followed the law. They might not have followed their own processes. They may have failed to provide you with the information you needed to make decisions, or failed to keep adequate records. They may have not taken relevant things into account. They may have failed to investigate or dealt with inquiries, failed to follow laws. They may have made misleading or inaccurate statements. There may be bias, delay, neglect, various other, incompetence, bad decision making, poor advice, or failure to inform someone of their rights. Now, these are administration, but bear in mind that some of this might cross over to the decision that was made, which they're not going to look at in terms of whether they think it was a good decision or the right decision, but rather the process that they come to that decision. An example of this is your rights under the SEND regs. I think it's a SEND Reg 6H, where in the EHCP needs assessment, the local authority should take the advice of or consider taking the advice of anyone that the parents think is reasonably requested. I've made complaints under that before for failure to take advice from a clinical psychologist, where I thought that it was very reasonable that I made the request that they took the advice from them. And the response from the LGO is, well, they followed the process and considered your request, which is what they have to do. Whether it was right of them to refuse is another matter, but they followed the process they needed to take. So it's just an example of how they're looking at the process rather than actually the decision that they're making there. They weren't looking at whether or not they were right to deem it not reasonable. So what's the process? So you'll submit your complaint to the LGO, and the first thing they'll do is have a look at your complaint and see whether or not they should investigate it. So they'll assess, and then they'll let you know. Sorry, on my drawer, I was chasing the around garden metal bar. Sorry, right, what's going on? So they'll decide whether or not they're going to investigate. They'll assess the facts of the information. Once they have decided to investigate, they will contact you. They might contact you before that to get a bit more information. Then the next stage is they need to establish the facts. So it will be assigned to an investigator. That investigator will contact you. They often have a phone call with you, and they will have read the paperwork and they will ask you some more information. They then write to you and sort of lay out where they're at, and they also write to the local authority. And at that stage, they're asking the local authority to provide them with a lot of the evidence, a lot of the information, so emails and so forth, minutes and everything. Once they've got all that, they will investigate. And once they've completed their investigation, they will send you, the parents, the draft report, and they'll also send the draft report to the local authority. And they will ask you for your comments, and they'll ask the local authority their comments. And you can challenge certain things at this stage if you think there's some factual inaccuracies, for example. The local authority may do as well. If you think that there's no issues that they haven't covered, you could point that out. If you think that there might be evidence that they haven't seen that you think they ought to have seen, they will consider your feedback and the local authorities' feedback, and they will make a decision what they do with it, and then they will issue the final report, and they will send that to you and to the local authority as well. And that will tell the local authority, or tell you whether they uphold your complaints and what it is that, if they do, they're ordering the local authority to do. If you're unhappy with the outcome, then you've got a certain time limit, which, forgive me, I can't remember off the top of my head. It's not very long. I think it's 4 weeks to go back to the LGO and say that you're unhappy with their findings. But you need to be really clear. You can't just go, I'm happy. I don't agree with what you found. You need to be really clear about why you're unhappy. And so I would look at these points. I would look at whether or not the LGO has found maladministration. If they haven't, you might want to explain clearly what you think they've missed, or why you think what they've discovered in their investigation does demonstrate maladministration. You may find that they have found maladministration, they have agreed with you, but they don't think it's caused you much injustice. This has certainly happened to me before, and I very much disagreed with them. But I didn't really get very far with it. So, but you might want to go back and go, well, actually, I disagree. It's caused me a lot of injustice because of X, Y, Z. You might think that the recommendations they make don't match the findings that they've come with from the investigation. You'll need evidence there that, that the recommendations ought to be different. So the LGO do publish cases that are anonymised. So you can go, you ought to, in that situation, go away and find similar cases where the recommendations are different and refer to them. And certainly if you a particularly large amount of brain power available to you before you make your complaint, you might want to go away and have a look at similar findings before you actually put the complaint to the LGO, to have a look at the sorts of remedies and the sorts of recommendations that have been made. So that's the LGO. So that kind of sums up that situation. So you get your final report, and that will tell, it will say whether they find fault or not. It will go to the local authority, and there will be certain orders in there if they found in favour of you, and it will say that they need to do X, Y, and Z, and by which date. And if there's financial remedies, it will tell them what they are and order them to contact you to put that into place. So that's the LGO. Look briefly at judicial reviews. So if you're challenging a decision that a local authority has made that you can't take to SENDIS, it's not an appealable decision, then you can challenge decisions made by local public bodies by this process of judicial review. Now, it's the remedy of last resort. So if there is another available remedy to you, then you have to take it. So, for example, if the decision is appealable, then you have to use that process. You have to go to a tribunal, for example. And there's 3 grounds of claims that you can claim under for judicial review. You can claim under irrationality or unreasonableness. You can claim under illegality. You can claim under procedural fairness or impropriety. Like all of these things in law, there are definitions of what these things mean that we need to follow. We can't just say, right, this is irrational, I think it's irrational. So, irrational and unreasonableness. There's a really high threshold for claims under irrational, unreasonable. And probably we would like there to be another grounds to one of the other 2 grounds as well. But how we define irrational and unreasonable is that a decision is outrageous or absurd, that it defies logic and no reasonable body of persons could have reached it, where reasoning involved a serious logical and methodological, if I pronounce that right, error. So, for example, it could be irrational if it takes into account irrelevant considerations, or it fails to take into account relevant material decisions. If it failed to ask the right questions, or if it failed to ensure there's enough information to take a decision. That's what we're trying to prove if we're looking at irrational and reasonable. Illegality might be that they've acted beyond their powers, or that they've unlawfully fettered its discretion. Essentially, the sorts of things we might be looking at there is if they have blanket policies. So if they say that they won't assess, I can't think of blanket policy off the top of my head, but they'll never give alternative provision unless they have a letter from a consultant or something, and they apply this policy to blanket to everybody without taking into account the specific situation of the case. It may be illegal, it may cover illegality if they've made an error in law, or that they've breached their statutory requirements, so breaching statutory timescales for issuing a new HC plan, breaching statutory timescales following an annual review, for example. Or it may breach the Human Rights Act as well. And then we've got procedural fairness or impropriety. So failing to follow procedural requirements set out in law, bias or the appearance of bias, abuse of power, or if it hasn't acted in a way it says it would do. You don't need to worry too much about this because it's not you that you wouldn't start the judicial review proceedings. So the process of this is so you need to understand that following a judicial review process, it's a legal process and therefore legal criteria must be met. So you need someone with the legal knowledge to be able to assess the situation and help you come to the decision as to whether or not this is something that can happen. So, for example, you want to approach someone like us or a solicitor who has specific experience of send law and judicial review to find out if your complaint's viable. And they will look at the specific circumstances. You need to be very careful about using somebody who doesn't have, who isn't a solicitor or doesn't come. For example, when SOSIN does it, our solicitor is kind of checking the viability, for example, and they've got that really specific background. And the next stage then is for this legal letter to be written, which is called a pre-action protocol letter. And these letters have to follow a very specific format, and they're very formal and legalistic. So again, you need to get somebody who knows what they're doing to write that letter. For example, SOSIN can write the PAPs. Now, PAPs can be quite powerful. So pre-action protocol letters can be powerful because what we hope is that the issuing of the pre-action protocol letter in and of itself is going to resolve the situation. And it can be very effective in situations that are quite straightforward. So, for example, if your local authority has failed to follow timelines after an annual review, and they haven't issued you with your letter to say whether or not they're going to amend, cease or maintain, or they haven't issued your final plan following an annual review, then we can lay that out very clearly. They clearly haven't followed law, and we can say that the remedy is we want you to issue that final plan or issue the letter, say if you intend to cease, plan or maintain, and therefore giving yourself the right appeal. So we can ask them to ask the LA to do something. There are times when it might be something you could prevent an LA from doing something. So the example here is closing a respite centre. That doesn't necessarily apply to what we would do, but it gives you an example. They could be asked to set aside a decision and relook at the decision. It could declare that the local authority has acted unlawfully. Yeah. So how we tend to use, let me unshare my screen quickly. How we tend to hope that pre-action protocol letters work is that they in and of themselves resolve your situation and get action from the local authority. And I think they can be very effective because they land on the desk of the solicitors and the legal department at the local authority, as well as landing with often your caseworker. And so what I like to think is that the solicitors can kind of go to the caseworker and say, come on, this is a very clear breach of guidance in law here. We need to do this. If you find that it doesn't have that effect, and I think it's very rare that it doesn't, then the other reason why they're effective is that the next step of the proceedings, if you do need to go to judicial review, it generally will be able to be done via legal aid because it's done in the child's name. So it's a course of legal action that doesn't have a lot of financial burden for the parents, and therefore it's open to more people. And therefore local authorities know that parents can follow that as a process. So it can be a very effective way of getting certain things done there. Failure to provide provision in Section F of the plan, for example, or failure to provide Section 19 alternative provision. So those are our different routes. That is the presentation done. I'm very happy to answer questions. I don't know if there's anything in the chat. It's quite straightforward, this one, but you might have questions. Corinne.
Hi, yeah, I've got a question. So the reason why I joined the webinar today is because my son has an EHCP, but school aren't doing any of the reasonable adjustments in the Section F.
Okay.
He's actually, it's a bit like your example earlier, he's actually not been able to attend school for a few weeks now. I mean, it's took about a couple of years to get to this stage. He's had 2 or 3 days off a week for a long time now, but he just basically, he feels like he can't go in. He's like he's broken the trust now with them. And I mean, from what you're saying, it sounds as though that would be more the judicial review rather than the LGO. Is that right?
Yeah. So I think Language is really important here. So section F of the plan is not reasonable adjustments. Reasonable adjustments are something that they have to provide under the Equality Act. Section F of the plan is legally enforceable provision. The duty to provide that provision is actually on the local authority. And I think you've got a number of different things going on here. I think that comes down to how specific and quantified your plan is. So wording, this is why wording in section F of EHCPs is so important. If your wording is vague, then actually it's very difficult to enforce that even by judicial review. So, you know, if your plan says that Tommy should have access to an LSA, it doesn't really mean anything. What does access to an LSA mean? You know, there might be an LSA in the room that they can, one in the school, and go and talk to. Whereas if it's Tommy must have a one-to-one LSA for 25 hours a week, dedicated one-to-one, then that's more enforceable. So I think I think what you need is some specific advice here based on your documents. If he's out of school, then other guidance and legislation comes in. So we've got the guidance to provide alternative provision or a suitable education for children who've been out of school for 15 days or more in an academic year, and that duty comes under section 19 of the 96 Education Act. You would need evidence as to why he's not in school. So, you know, if you can get something from your GP or from another health professional that's involved. But I think what you probably need to do is perhaps speak to one of our volunteers so that they can ask you really specific questions and help you identify where. Yes, the short answer is potentially a correction protocol letter is the way to go here. But in order to kind of establish that for certain, establish whether or not you've got everything you need in order to do that, we just need to check some specifics with your circumstances.
Mm.
Does that help?
It does. I suppose I hadn't really distinguished, just like because it's the first time I've ever had an EHCP done. To me, reasonable adjustments would be they wouldn't even need an EHCP. They're just
Absolutely
like what you get in a workplace. That's what I'm kind of basing it on. So could I have still complained about just them not making reasonable adjustments, even if there wasn't an EHCP been written?
Potentially. I mean, that would be to the school and following the school's complaints process.
Yeah, I'm doing that as well.
In that situation. I think for me, with complaints, it all comes down to, I think as some parents, we have a finite amount of energy, a finite amount of resources, time, brain power, all of that. So I think it's when I'm looking at complaints, I'm thinking always focusing, what am I trying to achieve here? So I think in a circumstance like yours, it's really looking at what's the ultimate outcome that we want to achieve there. Do you think, this is a rhetorical question, but do you think this is actually the school that can meet your child's needs? If not, then probably the outcome you're really seeking to achieve here is a change of placement. And therefore, that process is going to need to be done by a review of the plan and by making a request for a change of placement and then potentially appealing that decision. And so you would want to follow that process. If it's that you think it is the right school for him, so long as they did X, Y, Z,
yeah,
is that? So then it's looking at his EHCP. Is his EHCP properly quantified and specified? Is the provision he needs to do that actually laid out in his plan in a way that is enforceable? If not, then your energy is probably best spent again in appealing that plan when you've got a right to appeal and getting that plan properly enforceable. And then if they're not doing it, then you can follow the judicial review process. If schools complaints processes can be helpful. It's a different thing altogether. But again, you need to be really clear about what you're complaining about. But I think it's working out why they're not delivering it. Is it a matter of resources? But I think it often comes down to the wording in section F and making sure that's clear.
Yeah, I mean, in his case, to me, it seems as though they're just being inflexible and they're just, treating him like a one size fits all for it's only things like having, like it says, like break the lesson up so he has like 20-minute chunks rather than You know, it's only like, it's not things that cost any money in the Section F. It's things that just need them to be a little bit more flexible, like extra breaks and that sort of thing.
So that, in terms of following that via judicial review, it's quite hard. It's not very specific. So, you know, if it just says, right, it needs extra breaks, what does an extra break look like? What does that mean? How often? You know, an extra break could be that he gets to sit there, you know, and chill for a minute. So there isn't really anything quantifiable necessarily to be able to follow the JR process with, but also then it is about proving that they're not happening, and that's very difficult.
Yeah, how can you prove an absence of something? Because in
Exactly.
their response to my stage 1 letter to the school, they've just said, oh, we're doing it all, and we've looked at all the evidence and we're doing it all. And I just
Exactly.
don't see how you can do that. But one of the points is that they communicate with me. They have a method of communication with me, and they're not. I definitely know they're not doing that because I don't get anything. So I don't.
No.
It's just like someone's telling you black's white, and you're like, well, I know it's not. I know it's black. So what do I do now?
Yeah. I think it's a very difficult situation to be in all honesty. Then I come down to pragmatics. Are the school, you know, we might think that the school can meet need if only they tried harder, but do they want to, and are they going to? And then I start to consider, if it's me, actually, is this the right placement for my child, or would they be better off somewhere else?
I know what you mean, but because he's in year 6, he's only got a few weeks left. I don't really feel like it's the right time to move him somewhere else.
No.
Why should he miss out on his friendship groups, you know, all the way? It's like his last year of primary, towards the end of his last year of primary.
Yeah. So then I'm
Fair.
looking at it. I'm thinking about it pragmatically. I'm thinking about the fact that, you know, it's the summer term. Most routes through the complaints now are going to not be exhausted by the time the summer term's ended. So what do I want out of this for my son? I want him to be able to be in, you know, events. So how do I make that happen? And follow the route to enable that to happen, and be, you know, I think fighting about specifics on Section F when it's quite vague and they're saying they're doing it is not going to get you what it is that it sounds like you want, which is for your son to be able to partake in kind of the end of school stuff that's going on. So then I'm thinking, right, so actually how do I make that happen? What would make it work, and how do I work with the school to mean that he can at least do those things?
I think school would have to like reach out to him in some way, and you know, because he feels like his trust is broken with school, that they're not keeping him safe. He doesn't feel
No,
safe.
I completely understand. It might be that there isn't a way that you can resolve this. Like, if they're not going to reach out to him, even if they agree to reach out to him, it might not be in a way that ends up being helpful.
Yeah, I'm not sure they even would do that. These just seem very arrogant and sure of themselves, really, and just running the clock down, basically.
Yeah, and sometimes I think for me the reality is it's working out, you know, am I going to get what I want, and is this worth the use of my energy? And I make those decisions as well based on the fact that I only have so much, and I've got lots of other fights to fight as well. And therefore, am I going to get from it what it is that I want? I'm always focused on what is it I want out of this, and is me following this going to achieve that? And what do I want? What do I want for my child? What do I want to achieve? I think pragmaticness has to come into it as well.
Yeah, it's interesting. Yeah, thanks for that.
Otherwise, we kind of kill ourselves, I think, with fighting, you know, numerous battles. It's not the answer I'd like to be able to give. I think it's the answer from a fellow SEND parent that's fought many fights and learned the hard way on some of these things, I think.
Yeah, I mean, that's part of, I don't want to sort of dominate this conversation or anything like that, but
No, that's
partly what I'm thinking about in case other people have questions. But I'm sort of thinking about the children that come after him, which might sound a bit strange, like, because, you know, I've obviously got a lot going on with him. But I think, well, even if this doesn't, like, this complaining doesn't resolve things for my son, for Evan, what about the next child, you know, that they do this to? That's kind of what's in my mind, I think.
I get that. I absolutely get that. And you ask somebody else and they may give you a different answer to me. But my view is on that, from the sounds of it, is your complaint really going to make a difference to what do they want to change? It doesn't sound like it's going to make that difference. and there again, that for me, and again, this totally comes down to personal choice. For me, I pick those battles very carefully, and I think realistically, is it going to achieve that? And often I think the answer is no on that one, unless there's a real desire to learn, and there isn't always.
It's quite shocking actually. Going through it.
Yeah, these aren't. Yeah, they're I think they're realistic answers as opposed to what I would like to be able to say. But I think it's I think it's you have got plenty of battles to fight coming up. I think it's working out how to do that in a way that allows you to maintain your well-being in that as well, and that will be different for everybody. Thank you. I mean, I think it's helpful because people will be able to apply your situation to themselves as well, and be thinking about things. Is there anybody else with any other questions they would like to ask?
Can I just ask a quick question, please? How
Yes.
do you calculate quantum for a financial remedy?
So
the local government
ombudsman issues guidance. So if you Google it, you can find their guidance for financial remedy, and they have set ideas on what that ought to be.
And then presumably you can use that then to go back to your local authority if you're going through their complaints process to say, for X number of months of missed education, I calculate X amount should be payable, and then add on things like, for example, inconvenience and stress and whatever else the methods are, and whatever other items that can be added. So presumably that's how you would do it. Is that right?
That's what I do. Yeah. I mean, I've never known a local authority to give me that without me going to the LGO. And the amount for stress and injustice is not huge. But yeah, that's I don't calculate it. I turn around and say to them, I want you to follow LGO guidance. I want you to look at financial compensation following LGO guidance.
Okay.
But generally, you need to go to the LGO for it as a rule.
Okay.
I think the other reason to go to the LGO, which I meant to say before and forgot, is that the LGO do keep track of complaints, and if they start to see themes coming up from perspective from certain local authorities, then they do start to kind of address them on a wider level. So they've passed comment. Surrey is my local council, but on the regularity that they're dealing with failure to provide Section 19 education, for example. So one of the reasons I go to the LGO is because I know it's an issue that my local authority is failing on a regular basis, and I want that recorded officially. I want those statistics recorded, and so that would be a reason why I take it to the LGO.
And what is what's the position where you've got an appeal? Well, you've got an ongoing appeal, but you want to make a complaint as well. So, say for example, 10 months of failure to provide any education. The appeal is lodged in month 5 and registered in month 5. When the LGO would come in, would they then look at the first 5 months and then not the second, or would they say it's completely outside our remit?
It really depends on the exact situation for each person. So it's kind of impossible to really give an absolute definite on that. Why is the child out of school? What evidence is there? What's the local authority done about it? And I do find that it's variable depending on the person that's investigating it as well. So I've had various variable decisions on that. But I think for me, part of that comes down to trying to be very clear when you submit the complaint as to what the facts are, and trying to lay that out very clearly. So, if you've got medical evidence, when you got it, how you know that the LA has had it, who it was from, how that fits in with guidance. So kind of trying to lay that out very clearly. But yeah, I think it depends on the circumstances in that case, in each case. Any other questions?
No, I don't think so, Megan. So I'll just take this opportunity to thank you so much for the webinar tonight.
No worries.
And thank you everyone for joining, and I hope you found that informative and helpful. So thank you ever so much.
Thanks, Em.
Thanks,
Bye-bye.
Megan.